We are both the National Human Rights Institution and the National Equality Body. And I suppose a huge part of our work, I suppose our overall work, is to review the adequacy and effectiveness of law, policy and practice in the state. But we have a particular focus in our institution on a sustained engagement with international human rights monitoring processes, both at the UN and the Council of Europe level. And as well as that, then we do a lot of work domestically in terms of human rights and equality monitoring, legislative oversight, and a great raft of legal work, whether it's casework, amicus curiae, or legal assistance. So we've got a wide range of work, but myself and my colleague Naomi, who's with us today, we work primarily on the international reporting side of things, both at a UN and a Council of Europe level. So just move on then to the sorry, I just have a couple of words of background for you. So basically, Ireland has ratified both the 64 and the revised charter, and has also ratified the additional protocol for collective complaints, although it hasn't declared and it hasn't made a declaration enabling organisations like ourselves to take collective or to submit collective complaints as of yet. I suppose from our perspective as a commission, we have a very significant strategic focus on socio-economic rights, economic, social and cultural rights in our previous strategy statement, but also in our current strategy statement. And that, coupled with our sustained engagement with international human rights reporting, really lends itself to the engagement with the European Social Charter process. And we made a strategic decision back in 2017 to begin and to sustain our engagement with that process. And over the course of the last few years, we've done that both in terms of the thematic reports, but also in terms of our commentary on the collective complaints as well. We're in the process of preparing a report for the 18th national report, which is due at the end of June. So it's become a yearly calendar item for us at this point. And depending on what's on the dance card, so to speak, in a given year, it might be more extensive or more straightforward. But it's become a kind of a core part of our work. So just moving on then to the approach and the key barriers. I suppose, first of all, the approach that we take really is that we incorporate the engagement that we have with the Social Charter really into our wider work. You know, we've got a very wide program of legal policy research work, civil society engagement work as well. So in some ways, engagement with the Social Charter process is about deploying that work, deploying our policy work, deploying our research work, deploying our legal work effectively, and ensuring it has an audience where it can have impact. So with that in mind, the work that we do to engage with the Social Charter process does not necessarily involve a great deal of ab initio work from scratch. What it involves is us marshalling that information, marshalling that insight that we have as a National Human Rights Institution, and making sure that it is made known to the committee and that it's illustrated to the committee so that they can use it in their analysis. It also provides an advantage. The Social Charter, by its nature, and the way of working of the committee with the yearly thematic focus, means that there's a much better opportunity for granularity when it comes to the issues. So unlike the UN system, which is an awful lot more broad and also an awful lot more disparate across the calendars, you know, you might have 5-year gaps. With the Council of Europe, and particularly with the Social Charter system, you do get that touch point every year on one or on a number of topics. So the barrier really is resourcing for most of us. And we talked about this on Monday, that a lot of organizations wonder how much they can pour into engagement with the Social Charter process, given the resources that they have. And what I'd say about that is, first of all, I'd say a number of things. First of all, we approach it drawing from the work that we already do to a great extent. Secondly, I suppose the more you engage with the process, the more it becomes part of your calendar, it becomes part of your process, and becomes part of how you do your business year to year. And in a way, it becomes easier as a result of that. It just becomes part of how you work and how you record your intentions to deploy the work and the outputs that you have as a National Human Rights Institution. Also, there's a massive buildup of expertise on how the Charter works. I think between myself and Naomi here and a number of my other colleagues, we went a few years ago from knowing very little about the process, and we've talked about how Byzantine it can be in certain respects, to actually being quite comfortable with the process as well. So you do build up that expertise and you get a sense of what's useful to the committee as a result. I would just say as well, the effort is really worth it. I think the return is really worth it. You know, it's clear to us from our time over the past few years that our engagement has been very much appreciated, and it has had an impact, and it has, I think, assisted the committee in being alerted to various things. And I can tell you a little bit more about that in a minute. So what I might do is I might just move on to some, I suppose, more concrete examples from our work. So first of all, I might just talk about the March 2020 conclusions of the committee, which came out just last year, and it was on thematic group 4. So the items for scrutiny at that point were children, families, and migrants. That would be the kind of the cluster of issues that we were asked to have a look at. We wrote a report and we sent it in to the committee the previous year in 2019. And I suppose in broad strokes, there were approximately 52 references in the committee's analysis to our comments, which just gives a sense of the degree to which the committee used and found useful the comments that we made and the analysis that we deployed. It's worth saying much of this analysis, as I said, was drawn from work that we do as an NHRI and then deployed in that way. So again, not ab initio work. It was also clear that quite a bit of our material and data was used in the conclusions, and I suppose it provided a rounder picture to the commission, to the committee, I should say, of issues under those various topics. So I'll give you some examples. There were a number of issues that had been maybe underplayed or excluded from the state report that we took the opportunity to highlight. So, you know, we talked, for example, about data collection, online safety for children, the habitual residence condition, children in care, separation of children in detention, the use of reduced class timetables for certain children, and the gaps in legal interpretation services. So they're just a range of issues that we touched on quite actively in our report, and which the committee found useful in terms of assisting them in getting a rounder picture of where the gaps and the issues were. So I suppose in terms of particular gaps or areas where we felt we found a bit of impact would be that, you know, the committee's remarks on trafficking, sexual exploitation of children, domestic violence, school admission policies. These are areas where we had very long-standing and very clear analysis and perspectives, which maybe were not quite the same as how the state would have gone about talking about them, if at all. And that really assisted the committee. So, for example, there were findings of non-conformity with Article 16 on affordable childcare and Article 19 on family reunification appeals processes, that latter piece being a massive strategic priority for the Commission over a number of years. So to engage with the process and then see a finding of non-conformity like that, it assists us in our work as well. So as well as us assisting the committee, that gives us more, I suppose, weight in terms of the analysis that we continue to deploy domestically, but also the advocacy that we need to deploy domestically. So I'll just move on then to the next slide, which is a slide on, sustained engagement. I was just going to look at a topic, a core strategic issue of ours, which is traveller accommodation. Now, this actually has a thematic link with the collective complaints process, insofar as, pardon me, the committee came to a decision of non-conformity with Article 16 with regards to Ireland's inadequate protection of travellers in respect of accommodation and housing, and also eviction policy. So once we got involved in providing commentary to the committee, drawn into that would be commentary on the degree to which the state has responded to this finding of non-conformity, and we have made a number of detailed comments to the committee in its reviews of this case, and there are subsequent findings of ongoing non-conformity when it comes to Ireland's policy around traveller accommodation. And I think this is important because it ties into the work of us as a domestic national human rights institution, where the issue of traveller accommodation and the lack of provision of culturally appropriate traveller accommodation in Ireland remains an enormous issue, and an issue that we are working on quite actively. For example, in our quality review line of work, in our scrutiny of local council decision-making processes, in our amicus curiae work, in our casework, where we bring cases and legal assistance on behalf of people. So engaging with this process at the Council of Europe level really helps us to ensure that a wide number of scrutinizing bodies are aware of the issues, but also that they come to conclusions that we can use then in our own work. The conclusions drawn by the Committee on Social Rights are useful to us when we go to other fora, when we talk to Parliament, when we engage in United Nations level treaty monitoring, when we engage in the UPR. We're currently drafting our report to the Human Rights Council on the UPR. We make direct reference to this very case in that. Myself and Naomi were working on that this morning, actually, and also in our legal casework, in the council briefs that we write up for our work in court, relying upon these analyses by bodies such as the committee are really valuable to us. So I suppose in terms of some of the places where we've done that, I think the Parliamentary Committee on Key Issues Affecting the Traveller Community would be the most recent one in the Irish context, where we really used a lot of the work, a lot of the analysis of the European Social Committee, Commission on Social Rights, when it comes to that line of work. So I think, again, it's very much a question of deploying work one already has and seeing the value in engaging with the committee under the charter to bring added value to it, and to kind of open another front in terms of the scrutiny of the state where these issues are concerned. I suppose I just might move on to, and we can come back, we can talk about this in more detail with Q&A, but we had on the list for the brief was a list of suggested improvements to this, and so on. Now, I didn't go into this in as much detail as I had originally planned, simply because a lot of that was discussed on Monday in terms of some of the challenges that organisations have and that NHRIs have in understanding and navigating the procedure of the system. And there was a lot of discussion how tricky it can be and how difficult it can be, and I tend to agree with that. I think it is a little bit hard to get one's head around. It's quite complex, and it took us a good bit of time over the course of the last 4 years to get our heads around it. And those of you who were there on Monday will notice that both myself and Naomi, having worked on this for 4 years, still had a couple of questions for Niamh and for Aoife as well. So it is something that is an ongoing thing. But so I think there's definitely value in making the process clearer and more accessible, provision of clear informational materials, and a bit more clarity around some of the ambiguities that exist within the online information currently. But I would stress, though, that the Secretariat is always so helpful. Like any time I drop a line to Niamh, for example, or colleagues there, we always get the information we need and we're able to act accordingly. So in the absence of maybe that clarity just going in cold, there's an open door there, I think, in terms of just finding out what you need to find out. So that's certainly been our experience. I was going to just talk about some tips then for successful or effective engagement with this process as a NHRI or an equality body. First of all, I think sustained engagement is well worth it. Okay, and this is coming from the perspective of an organisation that has taken an active strategic decision to engage in a sustained, rolling, comprehensive way with all the UN treaty monitoring bodies and with most of the Council of Europe monitoring bodies as well. So, and in some ways, that sustained engagement means that you always have good material, you always have good perspectives, but also it's an engagement that encourages cross-treaty and cross-institutional and cross-jurisdictional analysis of the human rights problems or issues that a country might have. So I do think sustained engagement is very valuable. The particular value of this particular process is, as I said, that it permits regular follow-up, and there's always possibilities for new findings of non-conformity, and I suppose an opportunity to update with more granular detail in a way that the UN system really can't sustain and it really isn't designed for. But the two approaches, or marrying a UN perspective and then a Council of Europe perspective, in this case, they do complement each other in terms of that rolling body of evidence and knowledge that one gets through those processes. I'd also say just present the available evidence, and that's just going back to what I said, deploy the work that you've already done, build on and adapt it to meet the needs of the particular reporting procedure. But the evidence is that you present, the perspectives and the policy positions that you present should and will be very much positions that you already have. It's about deploying them and giving them an audience where you mightn't have given them before. And connected to that then is cutting your cloth to measure. Sustained engagement does not necessarily mean that it takes over all your organization's work or all your team's work. It's about cutting your cloth to measure, identifying the thematics, identifying where you might be able to add value or provide insights to the committee that they may not otherwise get, and put the focus there. Sustained engagement doesn't mean blanket spreading yourself too thin, comprehensive engagement. It can be quite focused if that's where your priorities lie. Thematically, we found a lot of crossover between our strategic priorities and the social charter, simply because we have that perspective in our strategic approach. But there are certain of the collective complaints on which we have little to say because they don't really align with what we're focusing on at the moment. And when that happens, we just don't say very much, and that's absolutely fine. As I said, linking it in with United Nations treaty monitoring body work, which a lot of organizations do more as a matter of course, is a very good idea. It's entirely complementary. The issues are cross-cutting. And as I say, the charter provides more granularity and more kind of updates, if you like, that can feed back into the UN treaty monitoring process as well. Then advocacy, use the engagement for domestic advocacy. If there are findings of non-conformity, if there are commentaries that cast a light on issues in your country coming from this process, use them actively. That's certainly what we do, as I said, with the traveller accommodation issue, as I mentioned earlier on, amongst other issues. That's very much what you need to do. And that's, actively embracing what you get out of that process for domestic advocacy is entirely part of it and part of the process. And as Professor Nolan said the other day, the findings of non-conformity are very clear and they're regularly updated. And it is an extremely useful tool in domestic advocacy, regardless of whether they're directly implementable in Ireland or not. I think they provide a very useful tool for advocacy and for pushing the envelope when it comes to advocating for reform.